Do you have a criminal record and want to travel to the United States? Are you confused about whether you need a US entry waiver? In this video, I'm going to clear up the 5 biggest myths about US entry waivers for Canadians with criminal records. I'm Dan Joffe, US Waiver Lawyer. If you're looking for expert advice on traveling to the United States without stress, schedule a free call with me using the link in the description below. Let's get started and clear up each of these myths. Myth number 1, I got a pardon, I don't need a US entry waiver. Pardons or record suspensions have no power in the United States. They are not recognized by US Customs and Border Protection. That means the CBP can still deny your entry if they discover your criminal record. This is confusing because when you get a pardon, the Parole Board of Canada directs the RCMP to remove your criminal record from CPIC, which is the Criminal Records Database. However, the CBP can discover your criminal record if they review previous versions of CPIC, which they may have stored for ongoing access. So you may still need a US waiver even if you got a pardon. Myth number 2, I've never had a problem traveling to the United States. Just because you've never been denied entry to the US does not mean you won't have an issue in the future. When you approach the US border, you will be screened by a US CBP officer. If they conduct a criminal record check or suspect a problem, the CBP officer will pull you aside for what is called a secondary inspection. At that secondary inspection, you will be interviewed by a CBP officer who will conduct a criminal record check. Upon discovery of your criminal record, you may be denied entry into the United States. Myth number 3, my conviction was so long ago, it's been erased. That's not the case. Criminal records in Canada are effectively lifelong entries. With few exceptions, your record will not just disappear or get erased over time. This means the US CBP can still access old criminal records even from many years ago. And with upgrades in screening technology, the CBP is catching more and very old criminal records, resulting in denied entry to the United States. Myth number 4, it's a small charge and not a big deal. The CBP will deny entry to the United States for any crime when it is a crime involving moral turpitude. Now, crimes involving moral turpitude is a complex area of the law. What you think is a small charge could actually be a crime resulting in inadmissibility. For example, any marijuana possession conviction is a federal offense in the United States, which means you will need a US entry waiver. Myth number 5, if you don't have a criminal record, you can't be denied. This is not true. Let me give you an example. If you answer yes to a CBP officer question about marijuana use, you will be denied entry, and this will happen even though you don't have a criminal record. You will then need a US entry waiver to legally enter the United States. If you need help with understanding whether you need a US entry waiver to travel to the United States, reach out to schedule a free confidential call with me. The link is in the description of the video.